Welcome to Ask the Lawyer radio podcast with attorney Brian Figeroux of the law firm Figeroux Associates. This podcast features a recording of our most recent radio show aired weekly in New York City. We hope you enjoy the show, which features news, views, and interviews on matters such as immigration, personal injury, bankruptcy, divorce, family law, estate planning, wills and probate, deed transfers, civil rights, criminal defense, workers' compensation, and taxes, both individual and business. You can contact us at 855-768-8845 or visit us at www.askthelawyer.us. You have questions? We've got the answers.
Citizenship. Applications in 2025 amidst heightened scrutiny by the Trump administration. The process of applying for U.S. citizenship has always been complex, but in 2025, under the Trump administration's intensified immigration policies, the path to naturalization has become even more challenging. With an ongoing crackdown on immigrants, naturalization applications face increased scrutiny, particularly for those who obtained green cards through marriage. If the marriage ended in a contentious divorce, applicants may face additional hurdles, including potential interference from a vindictive ex-spouse. Given these obstacles, seeking experienced legal representation is more crucial than ever. This article analyzes the current climate surrounding citizenship applications, the risks posed by past relationships, and why working with a seasoned immigration attorney is critical to successfully navigating the process. The Trump administration's war on immigrants. Since returning to office in 2025, President Trump has reinforced his administration's hardline stance on immigration. A key focus of his second term has been limiting pathways to U.S. citizenship, particularly by increasing scrutiny on applications. Several measures have been implemented to slow down or deny applications, including stricter review of marriage-based green cards. The USCIS, United States Citizenship and Immigration Services, has intensified investigations into marriage-based green cards with a greater focus on potential fraud, even after divorce. Longer processing times. Citizenship applications now face prolonged review periods, with additional background checks and higher denial rates. More requests for evidence, RFEs. Applicants are now more likely to receive RFEs, requiring them to submit additional proof of their eligibility, adding further delays. Political and racial biases. Immigrants from specific countries and ethnic backgrounds face disproportionate scrutiny, a hallmark of previous Trump immigration policies that has resurfaced. For those who obtained a green card through marriage and are now applying for citizenship post-divorce, these policy changes present significant challenges. The complications of marriage-based green cards and divorce. One of the biggest hurdles for naturalization applicants who obtain their green card through marriage is proving that their marriage was legitimate, especially if the relationship ended poorly. USCIS has historically been skeptical of marriage-based green cards, but under the Trump administration's policies, there is an even stronger presumption of fraud. Potential issues when applying for citizenship. Post-divorce. 1. USCIS scrutiny. Over the validity of the marriage, officers may dig into the marriage history, looking for inconsistencies that could suggest fraud. If the divorce was acrimonious, USCIS may see it as a red flag. 2. Ex-spouse interference. In contentious divorces, an ex-spouse could deliberately provide false or misleading information to USCIS. If the ex-spouse claims the marriage was fraudulent or submits derogatory statements, it could result in the applicant's naturalization denial. 3. Additional proof required. USCIS may require extensive evidence that the marriage was genuine, including affidavits, financial records, photographs, and testimonies. A request for evidence, RFE, or notice of intent to deny, NOID, could be issued, demanding more proof or an explanation for discrepancies. Legal challenges in citizenship. Applications under stricter policies. With citizenship applications facing more obstacles, it is crucial for applicants, especially those with marriage-based green cards and past divorces, to anticipate and address potential complications early in the process. Common issues that could lead to citizenship. Denial, misinformation in previous immigration filings. If there are inconsistencies in the marriage-based green card application, they may be used against the applicant during the citizenship process. Allegations of marriage fraud. Even if untrue, an accusation from an ex-spouse can trigger a full investigation. Criminal or civil allegations stemming from divorce. If an ex-spouse has filed any restraining orders or legal complaints, these can negatively impact the application. Failure to meet continuous residence and good moral character requirements. USCIS may question whether the applicant has met the residency requirements or has maintained good moral character, especially if the ex-spouse presents damaging claims. Given these risks, citizenship applications should be handled by attorneys who are well-versed in immigration law and prepared to counter government scrutiny. The role of experienced immigration attorneys in 225 applying for citizenship under a hostile immigration climate requires legal expertise. A seasoned immigration attorney can anticipate USCIS scrutiny and prepare a strong application, ensuring that all paperwork is accurate, complete, and well-documented. Defend against accusations from a vindictive ex-spouse, counteracting false claims and gathering evidence to prove the legitimacy of the marriage. Respond to requests for evidence, RFEs, or notices of intent to deny, no IDs, crafting thorough responses to government inquiries to prevent application denials. Represent clients in immigration interviews, preparing applicants for questioning and advocating on their behalf during USCIS interviews. Appeal denied applications. If the application is denied, an attorney can file an appeal or motion to reopen the case. For applicants facing complex circumstances, securing legal representation is no longer optional. It is a necessity. More challenging than ever. The road to U.S. citizenship has never been easy, but in 2025, under President Trump's intensified immigration policies, it is more challenging than ever. Those who obtain their green cards through marriage and later divorced must navigate heightened scrutiny, potential interference from ex-spouses, and a system designed to slow or deny applications. To increase the chances of a successful naturalization process, applicants must be proactive, well-prepared, and legally protected. Seeking the guidance of experienced immigration attorneys, such as those at Figeroux Associates, is the best step toward ensuring a smooth and successful citizenship application. If you are facing immigration challenges, do not risk delays or denials. Consult with a legal professional today.
Are you applying for U.S. citizenship but facing complications? Under the Trump administration's harsh immigration policies, the process is tougher than ever, especially if you obtained your green card through marriage and later divorced. The government is scrutinizing applications, and a bitter ex-spouse could make things worse. At Figeroux Associates, we specialize in immigration law and will fight for your citizenship. We'll protect your rights, respond to government inquiries, and defend against false allegations. Don't let delays or denials stop your future. Call Figeroux Associates today at 855-768-8845 for a consultation. Visit us at 26 Court Street, Suite 701, Brooklyn, New York, 11242. Your citizenship is too important to leave to chance. Let us fight for you. Figeroux Associates. Justice, integrity, results.